Chile's position that the court has jurisdiction to give the requested advisory opinion, and that there are no compelling reasons for the court to refuse to do so. Some states have argued in the present proceedings that an advisory opinion would prejudge essential elements relevant to a pending case before this court, namely the proceeding brought by South Africa against Israel regarding the application of the Genocide Convention. Chile recalls that this court made clear in its interpretation of peace treaties advisory opinion that the court could decline to exercise its advisory jurisdiction in such cases where, and I quote, the question put to it was directly related to the main point of a dispute actually pending between two states, so that answering the question would be substantially equivalent to deciding the dispute between the parties. As was the case in interpretation of peace treaties, the question put to the court in the present proceedings does not touch the merits of the aforementioned pending dispute. And therefore, I quote, the legal position of the parties to this dispute cannot be in any way compromised by the answers that the court may give to the question put to it. In the pending dispute, South Africa is claiming that Israel is in breach of its obligations under the Genocide Convention. Thus, the relevant question for the court is whether the acts and omissions by Israel complained of by South Africa are genocidal in character and are intended to bring about the destruction of a substantial part of the Palestinian national, racial, and ethnic group. On the other hand, the question raised here concerns the obligation of Israel in relation to the presence and activities of the United Nations, including its agencies and bodies, other international organizations, and third states, which, as made clear by the delegations that have preceded me, encompass obligations that arise from several bodies of law, including international humanitarian law, international human rights law, and the privileges and immunities of international organizations. Therefore, although the provision of humanitarian assistance is an issue that arose in the case concerning the application of the Genocide Convention in the context of provisional measures, and it's also relevant to the present proceedings, Chile submits that it's not a question that directly relates to the court dispute of that case. Indeed, by answering the question put before it, the court would not be deciding any aspect of the dispute between the parties in the contentious proceeding, because there are no direct links between the questions raised in the case concerning the application of Genocide Convention and the question put to the court in the present proceedings. Thus, rendering an advisory opinion would not compromise the legal positions of the parties to the dispute, nor the fairness of the proceedings. Consequently, there are no compelling reasons for the court to refuse to render the advisory opinion. Mr. President, members of the court, this leads me to my second point regarding the scope of the question presented to the court and the applicable rules. The court has had the opportunity to make findings in relation to the situation of the occupied Palestinian territory on two occasions. First, on 9 July 2004, in its advisory opinion regarding the legal consequences of the construction of a wall, and second, 20 years later, on 19 July 2024, in its advisory opinion regarding the legal consequences that arise from Israel practices and policies in the OPT. In this context, the present proceedings are meant to complement the aforementioned opinions by addressing questions that had not yet been put before the court and consequently have not been answered. In particular, while the previous advisory opinions address the obligations that Israel has in relation to Palestinian people, the present question seeks to identify the obligations that Israel has toward other relevant actors operating in and in relation to the occupied Palestinian territory. More specifically, the question refers to the United Nations, including its agencies and bodies, other international organizations, and third states. The obligations that the court was requested to identify relate to all international organizations and states operating in and in relation to the OPT. However, Chile requests that the court take note of the grave concern expressed by the General Assembly in the preamble of its resolution 79/232, which informs the present request from advisory opinion in relation to, and I quote, plans and measures, including legislation adopted by Israel to interfere with or obstruct the presence and operation of the United Nations and the United Nations entities and organizations, including the United Nations Relief and Works Agency for Palestine refugees in the Near East. End of quote. As was submitted in our written statement, it is Chile's position that the relevant obligations arise from Israel's dual role as both an occupying power and a member of the United Nations. First, in its role as an occupying power, Israel is bound by international humanitarian law, particularly by the law of occupation and international human rights law where applicable. While it's true, as some have argued, that international humanitarian law does not directly focus on interaction between the occupying power and international organization or third state, it does focus on the protection of civilians and the occupied population. In that context, it establishes obligations to provide humanitarian relief and basic services to the occupied population. Furthermore, the Fourth Geneva Convention, to which Israel is a party, establishes a specific obligation for the occupying power to grant any relief organization all facilities necessary for it to achieve its purpose within the bounds set by military or security considerations. Chile notes that under Article 142 of the Fourth Geneva Convention, of the scope of the activities that may be undertaken by relief organization is quite broad and would certainly encompass the activities of all 13 United Nations entities that maintain an ongoing presence in the OPT, as has been identified by the UN Secretariat in the present proceedings. As clarified by the International Committee of the Red Cross in its 1958 commentary to Article 30 of the Fourth Geneva Convention, the obligation of the occupying power to grant all facilities to relief organization is not met by merely authorizing them to carry out their work. Rather, the occupying power must facilitate and promote their task. This means that it must, and I quote, take all necessary steps to allow approved organizations to take rapid and effective action wherever they ask to give assistance. End of quote. While this obligation is certainly limited by military necessity and security needs, this reservation must be interpreted restrictively and should not be read as a carte blanche for completely prohibiting the activities of such organizations, especially when they have been given a mandate to address the occupied population of a particular area by the General Assembly. Indeed, such limitations must only be imposed in good faith, and, I quote, shall not hinder the supply of effective and adequate relief to all protected persons, end of quote. For these reasons, the occupying power should show moderation in their use of this reservation, applying it only in cases of real necessity in an exceptional and temporary manner. These measures can never result in the paralysis of the relief effort. And while they last, the occupying power must make suitable arrangement on behalf of the protected population. Turning next to Israel's second role as a UN member state. Israel's obligation stem mainly from the UN Charter and the Convention on the Privileges and Immunities of the United Nations. For the sake of time, Chile directs the court's attention to its written submissions for the complete identification of all the relevant obligations that are applicable, and would like to highlight here the duty of all UN member states to collaborate with the United Nations enshrined in Article 2, Paragraph 5 and 56 of the UN Charter. It is Chile's position that this duty includes all bodies, agencies, and subsidiary organs of the United Nations, and involves not only the observance and implementation of the UN policies and decisions, but also an obligation to cooperate in good faith with the organizations and abstain from obstructing their mandate. Your Excellencies, while this duty certainly applies in relation to binding Security Council decisions, contrary to what has been argued by some participants in the present proceedings, Chile submits that this duty does not exclusively apply to action taken by the Security Council in accordance to Chapter 7. Indeed, this court has contradicted such narrow conception of the duty to collaborate in two ways. First, this court made clear that the Security Council can make binding decisions in exercise of any of its powers, not only those concerning enforcement actions under Chapter 7. Second, this court affirmed that, and I quote, the effective working of the organization, the accomplishment of its task, and the independence and effectiveness of the work of its agents, end of quote, requires the strict observance of the duty to cooperate under Article 2.5 of the UN Charter. Further, considering that the obligations contained in Article 2.5 is one of the principles of the organization under which member states must act in order to achieve the purpose of the United Nations, it follows that this duty of cooperation applies to activities of the organization and all its organs and agencies. A more restrictive interpretation would render this provision meaningless by limiting the scope of the principles of the Charter only to Article 25. Nevertheless, even if the court were to find that Article 2.5 only refers to Security Council decisions, Chile submits that the Security Council has decided to vest Israel with specific obligations to allow, facilitate, and enable the safe and unhindered delivery of humanitarian assistance in the OPT. and to, I quote, ensure the safety and security of United Nations and associated personnel, those of its specialized agencies, and all other personnel engaged in humanitarian relief activities consistent with international humanitarian law, with prejudice to the freedoms of movement and access. End of quote. Mr. President, with this, I conclude the first part of the Chile's presentation, and I kindly request that you give the floor to Mrs. Chiappini to address our last key point.
I thank Mr. Troncoso. I now give the floor to Ms. Valeria Chiappini. You have the floor, madam.
Mr. President, members of the court, it is an honor to appear before you on behalf of the Republic of Chile. In the remaining time, I will address the general obligation of all UN member states to accord to the United Nations such privileges and immunities as are necessary for the fulfillment of its purposes under Article 105 of the UN Charter. This obligation is further detailed in the Convention on the Privileges and Immunities of the United Nations, which I will herein refer to as the General Convention. This obligation is broad in scope and applies to all principal and subsidiary organs of the United Nations, whether or not member states have entered into any further agreement specifying them, or even if they have terminated such agreements. Concerning this obligation, Chile would like to emphasize that member states have a duty to guarantee immunity of jurisdiction and execution for the United Nations and its staff, and the inviolability of its premises, archives, and documents in a similar manner as those granted to diplomatic missions. To put it differently, these privileges and immunities are not subject to any qualification whatsoever. Nevertheless, some participants in the present proceedings have argued that these obligations would not be applicable where legitimate security concerns of a member state are undermined by an abuse of the agency's privileges and immunities. This, however, is not correct. The object and purpose of these privileges and immunities is to ensure the independence of the organization and to guarantee that it carries out its mandate without any undue interference or financial gain by the host state. Indeed, these privileges and immunities are only limited by that which is necessary for the organization's proper functioning. In short, United Nations member states are bound to accord the privileges and immunities that are necessary for the organization to perform their functions independently, effectively, and impartially. In this regard, while Chile condemns any abuse of these privileges and immunities that may occur, Chile recalls that member states are not allowed to take unilateral action against the privileges and immunities of the organization, its bodies, agencies, and staff in the presence of a perceived abuse. A specific provision to this effect was included in the Convention on the Privileges and Immunities of the Specialized Agencies, adopted 1 year after the General Convention. Section 24 of the Convention of the Specialized Agencies provides a mechanism for state parties to resolve a situation in which they consider there has been an abuse of a privilege or immunity, mandating them to engage in consultations with the concerned agency. If such consultations fail, it is this very court who needs to determine, through an advisory opinion, whether such an abuse has occurred before any measure can be taken by the host state. The original proposal of Subcommittee 1 of the 6th Committee of the General Assembly was granting state parties to that convention, in the event of such an abuse, the right to denounce it and terminate any obligation to give privileges and immunities to the specialized agencies of which it would still remain a member. However, that proposal was met with several objections, including, first, that if such a provision were to be incorporated, the Specialized Agencies Convention would diverge considerably from the General Convention, which does not grant such right of denunciation. Second, the provision would contradict the already accepted principle that specialized agencies should receive appropriate privileges and immunities as necessary to carry out their mandate. And third, it seemed wrong in principle to permit a state to have the advantages of being a member of a specialized agency while denying it privileges and immunities necessary for its operations. To be sure, Your Excellencies, while there is no similar provision contained in the General Convention, the same considerations still stand. Namely, permitting a member state to unilaterally strip the organization and its officials of their necessary privileges and immunities would defeat their very object and purpose. Indeed, in the United States Diplomatic and Consular Staff Interan case, the court affirmed the fundamental character of the principle of inviolability, and consequently found that the conduct of Iran would have been unjustified even if the alleged criminal activities of the United States had been established, mainly because the Vienna Conventions on Diplomatic and Consular Relations contained express provisions to address the abuse of privileges and immunities. Similarly, the General Convention offers sufficient assurances against the abuse of privileges and immunities. Sections 20 and 23 clearly establish, and I quote, that privileges and immunities are granted to officials and experts in the interest of the United Nations and not for the personal benefit of the individuals themselves, end of quote. And provide the Secretary General with the right and duty to waive the immunity of any official or expert in mission where such immunity would impede the course of justice. In addition, Section 21 of the General Convention provides an obligation to the United Nations, and I quote, to cooperate at all times with the appropriate authorities of members to facilitate the proper administration of justice, secure the observance of police regulations, and prevent the occurrence of any abuse in connection with the privileges, immunities, and facilities, end of quote. Mr. President, members of the court, Chile further recalls that under international law, measures of self-help are strictly limited to measures of retortion, countermeasures, and self-defense, and where tolerated, are always deemed a measure of last resort. In this regard, it is a well-established rule of international law that countermeasures cannot be exercised against privileges and immunities of any kind, including the inviolability of organs or agents of an international organization and of its premises, archives, and documents. Lastly, Chile notes, as explained by the UN Secretariat, that any concerns regarding the abuse of privileges and immunities of the organization must be properly brought to its attention to be considered in the context of its legal framework. In this connection, Chile stresses the importance that the relevant UN organs, including the General Assembly, strengthen its control over its agencies and subsidiary organs. If, however, after the appropriate intervention of the relevant organ,